Alright, gandang umaga po sa inyong lahat. Happy Valentine's Day. Oh, um, ako hindi happy yung Valentine's ko eh. For the last 10 years, hindi happy po yung Valentine's ko. And in any case, thank you very much for coming over to this hearing. And this is a continuation of the hearing on Senate Bill number 1490 or the ERC Governance Reform Act. Last January 16, we initially deliberated on this bill and we requested from the different stakeholders their respective position papers as to the matter. And upon reviewing the different position papers, we deemed it necessary to conduct another hearing in order to clarify things and to discuss in depth the various issues and the position papers that were submitted to us. Before we begin, let me ask the committee secretary to acknowledge our resource persons for this morning.
Good morning. I'd like to acknowledge our guests and resource persons for today's public hearing from the Department of Energy, ASEC Gerardo Erguisa Jr., from the Energy Regulatory Commission, Chairperson Agnes de Banadera, Commissioner Josefina Patricia Asirit, from the National Electrification Administration, Attorney Julius Lutilia, Attorney Alexander Paul Rivera, from the National Power Corporation, Mr. Urbano Mindiola. From the Power Sector Assets and Liabilities Management Corporation, Ms. Luisa Esteban. From the Philippine Electricity Market Corporation, Attorney Saturnino Juan. From the Department of Budget and Management, Ms. Iluminada Aloot. From the Manila Electric Company, Mr. Lawrence Fernandez. From the Private Electric Power Operators Association, Attorney Ranulfo Ocampo. From the Philippine Independent Power Producers Association, Attorney Ann Estorco Masias. From AC Energy, Attorney Ria Inocencio. From the Retail Electricity Suppliers Association, Mr. Raymond Rosius. From the Management Association of the Philippines, Mr. Ernesto Pantanco. From the Energy Policy and Development Program, Ms. Jane Alca Maureen Laborte and Ms. Jenny Layawen. From USAID B Leaders, Mr. Michael Pitlock, Senior Advisor. From Citizen Watch Philippines, Attorney Hannah May Viola. Sir.
Thank you, Comsec. And again, we're very blessed to be joined by our ERC chairperson, Attorney De Banadera, and another commissioner is also here with us, Attorney Asirit. Welcome back from your vacation. And we're also joined by Attorney Erquisa of the Department of Energy. And again, thank you to the stakeholders. Actually, this reform is not a new idea. Here in the Senate, this representation filed a bill to strengthen and to define the the power of the different personalities inside ERC. But upon review also of the bills that were filed in Congress, there are two bills actually in Congress that deals with reforms inside ERC. Chairman Lord Velasco of the House Committee on Energy filed his own version, and again, the Speaker, no less than the Speaker, filed his own version pertaining to reforms inside ERC. However, the version of the Speaker is quite different in a sense that it will abolish ERC and create a new one under the Department of Energy, which is a totally different concept altogether. Nevertheless, this representation thinks that ERC, a strong regulator, is a very important aspect to strengthen the power sector. And I think the ERC has been quite quite I think in the past ERC has been performing its duties quite well, even though there's a lot of constraints in budget, in talent, in some aspects of the regulation. So we saw it fit to just strengthen, no, the different responsibilities inside ERC. With that, we propose some concepts to the body, and we propose some concepts also to ERC, and that's why during the last hearing, we requested to comment for the stakeholders to comment on these various concepts that we set forth. Before we go into the meat of the bill, we would like to hear some updates from the chairman and also from Commissioner Asirit. We all know that we are given a 60-day reprieve for the board to convene and to do its job. But we just want to know also what is the strategy, what is the the plan for the next 60 days. During the last hearing, we heard that there are a lot of uncertainties that surround the power sector, especially when it comes to the approval of contracts. So we want to hear from the Commission on how to allay the fears and how to address the uncertainties that surround the power sector. So with that, we turn over the floor to the chairman and to ERC to give us some updates regarding the Commission.
Thank you very much, Mr. Senator. Good morning to everybody and happy Valentine. So, pwede ba isentro natin ng konti? Okay. So, we are giving you updates. Our commissioners actually reported only last Monday, and we had the commission meeting yesterday, Tuesday. So these are the updates on the 2 days that we've been functioning. Let me first present to you the Court of Appeals issuance of the temporary restraining order, which is directed against the Ombudsman order of suspension and also against the Office of the President, because the implementing authority is the Office of the President, the 4 commissioners being presidential appointees. And we have reproduced here the dispositive portion of the temporary restraining order, which, as we can see, is directed and is intended to avoid serious and irreparable disruption in the operation of the ERC and to prevent adverse repercussions on the power industry as a whole. The general rule on order of suspension, especially if it is a penalty, is that it is executory without need of any without need of going to court. And the implementing authority is the head of office if he is or she is the appointing authority. So in the case of the commissioners of the ERC, since the appointing authority is the president, it is the office of the president that needed that was given the responsibility of implementing. It was only on January 22 that we received the memo from the Office of the President directing the ERC chair to implement the suspension. And so it was late in the evening, it was late in the afternoon of January 22, so we were able to serve the 4 commissioners only on January 23rd. As we can see, the TRO is for 60 days, and the commissioners were required to post a bond equivalent to their 3-month salary. The 4 commissioners have already completed we were able to already make ERC function. Now, as I said, Monday they reported, Tuesday we had a commission meeting, and these are now the results of the commission meeting. We have approved for our new certificates of compliance. We already approved 2 from the Visayas with a total capacity of 175 megawatts, and for evaluation are 7, 5 in Luzon, 3 in the Visayas, bringing a total of 9 for our target for the entire 60 days. And for our certificates of compliance for renewal, next slide please. Yes, for inspection in Luzon we have 5, and we have 3 in the Visayas, or a total of 8. That will be issued renewal. And next slide. And in yesterday's commission meeting, we already granted extension of provisional authority to operate, or the PAL. And we have approved a total of 7. And for our target, we will be approving 19 more. This 19 have expiry dates up to June 2018. So in sum, we have approved 7, granted an extension of the PAL, and 2 so that they may continue to participate in WESM without any question. And for up to June 2018, we shall be able to act on them within the 60-day period. Now, for the order, next slide please. For the order and resolution, we shall, before the commission, is the application for fit-all by Transco. And while we already had a discussion on this in the commission prior to the suspension, we needed this to be presented as there was a motion that was filed by the intervenors. But this will be addressed within the 60-day period. We are also we will be acting on the amendments of the following: the rules for the distribution of net settlement surplus, resolution adopting the procedures in the event of market suspension or declaration of temporary market failure, and the subsequent market resumption of the operation of the wholesale electricity spot market. We shall also do the finalization of the rules supplementing the switching and billing process, and adopting a disconnection policy for contestable customers. So in fact, the target for the 60-day period will be the disposition of 60 cases, promulgation of 60 cases. This has been presented to the commission, but because of the suspension, the orders and the decisions and the resolutions were not signed by the commissioners and the chair, of course. And we also target the resolution of 40 more cases, which are new cases. So these are the cases that are going through the technical process, and we expect that we will be able to dispose of them too within the 60-day period. These are the limits, and we would like to be ambitious by really working harder than usual so that we can act more in the target that we have. We also have some innovations in the administrative process, such that all those that were acted upon yesterday during the commission meeting, in the afternoon we were able to sign ERCs to participate in the Western are very critically important. We already gave a letter to Pepsi so that they will be comfortable in making them participate in the Western. And for our Valentine's gift to our consumers, we have promulgated the resolution adopting the ERC rules for setting the distribution system loss cap and establishing performance incentive scheme for distribution efficiency. This has been signed and promulgated, Mr. Senator, and we are turning over to you a copy of our rules. Mr. Chairman, yan po ang nagawa namin sa 2 araw. So, increase that by 60 days, yan po ang magagawa pa namin. Maraming salamat po sa inyong pagsuporta.
Thank you. Thank you, Chairman. Kala ko Valentine's gift nyo sa akin. Date para mamaya, pero system loss pala yun. Ma'am, I just want to clarify things for the information of everyone. So we're given a 60-day window. And what should happen in terms of court action within that 60 days?
There are scenarios that we can anticipate. Within the 60-day period, the Court of Appeals may resolve the petition if they deem it proper, or they may just, the petition may not be resolved, in which case, at the end of the 60-day period, the commissioners will resume serving their suspension, Your Honor.
Okay. So within 60 days, it's either they throw out the suspension order and they can resume back to work, or yung suspension order i-upheld nila. Tuloy-tuloy po yung suspension. And for example po, the suspension order will be thrown out. Either way, no? Is that appealable to the Supreme Court?
That is still appealable, Your
And when you
Honor.
appeal to the Supreme Court, will the suspension stay or hindi po?
Depende po sa magiging namang aksyon ng Supreme Court.
So magiging
Because pag nag-file po ulit sila sa Supreme Court, then hihingi na naman po sila ng temporary restraining order. So depende na po ngayon sa Supreme Court.
So in other words, meron po hong uncertainty na magtuloy-tuloy beyond 60 days yung suspension.
Well, meron po, kaya po ang aming target ay para lamang sa 60 days.
Okay.
But we are ready for all the days.
Okay.
Thank you.
Ma'am, for the information of everyone, especially those ones who are not familiar with the power sector terminologies, itong COCs po, Certificates of Compliance, saan po kailangan to? Where do you use this?
Kailangan po nila para makaparticipate sa spot market na pinamamahalaan po ng PEMSI. Opo. So dito po merong trading. So although PEMSI issued a resolution as a stopgap mechanism such that even if the COPs have expired, because of the unused unusual and extraordinary situation, PEMC allowed the participation. Now there will be no more legal question because, and that's the reason why this is the extension of the COCs were the first in our agenda.
Okay. And here in your presentation, approved and for evaluation a total of 1,299 megawatts. This entire 1,299 megawatts will be hopefully approved within the 60-day period.
Actually po, for evaluation namin is 1,124.70.
Right, right.
Yes po. This will be acted upon by the Commission. Actually, priority po ito.
A priority. So
Opo.
hopefully within the 60
Yes, within the 60-day period po.
Ito pong 856 for inspection, will this be acted upon within the 60-day period?
Yes po, yes po. In fact, may mga schedules na po kami nito. So, the first 30 days, ito po magagawa na.
Alright. And then, ito pong provisional authority to operate, Madam Chair.
Opo.
Again, no, for the information of everyone, di ba po ginagamit tong provisional authority to operate?
Ito rin po yung konektado sa ating COC. Ito rin po yung kanilang kailangan ng ating nasa power industry para po makapag-participate continuously at the West End. Meron lang po konting mga kulang ito, kaya hindi umabot sa report namin ngayon.
Yes. But itong provisional authority to operate is not only for WESM but also to sell
Yes, operate.
to sell to the utilities, no?
Opo, lahat po.
Okay.
Lahat na po kasama.
So,
Po kasi may mga pending na point to point na hindi lang po hindi pa lang natapos kahapon, so hindi po namin aksyonan. But rest assured that ito po mga provisional authority for our GENCOs will be processed within the 60-day period.
and that's 990 megawatts.
Malaki po ito, opo,
Yeah.
tama po.
Okay. Attorney Arquisa, I saw that a lot of COCs and POW will be approved in the next 60 days. In your computation sa DOE, will this be sufficient to prevent brownout this coming summer?
Good morning, Mr. Chair. Well, so far the is concerned, let me start with the framework, Mr. Chair, that we do the planning and all of these are included in the implementation where we have to satisfy certain needs at a particular time. So currently at this point, we, as stated by the Secretary, we don't still have problems.
We don't. We
We don't have problems currently.
Currently, we don't have problems.
Yes,
Okay.
but of course, the concern of ERC here is with respect to a certain time frame.
Right.
Number one, with those that are going to be extended, just like business permits, whether or not they could proceed to undergo going into business. So, dito po, ginagawa na po nila yon. So that's one time frame. The another time frame po is the approval of new COCs. So far ginagawa po nila yon. At saka yung mga POW, so far ginagawa po nila. So at this point, wala po kaming nakikitang problema.
In the next 60 days, ngayon is Feb 14, so we're talking about papalo tayo until mga mid-April, no, which is the peak of the summer. No, and we all know that summer, the demand increases by about roughly 15 to 20%, no, depending on gaano kainit yung panahon. Again, no, with all of these COCs, POWs being approved, in your forecast, sufficient na ba ito para hindi tayo magkaroon ng brownout this coming March, April?
Currently, as of now, wala po kami nakikitang problema.
Wala akong
But
problema.
of course, we need to be addressing this very soon.
Of course, barring yung mga technical issues, assuming walang technical problems and then looking at all of this documentation, no, that will be approved in the next 60 days. Ang ano lang naman, ang aming gusto malaman is, sapat na ba ito? Is this sufficient already to fulfill what is going to be required for the summer months?
Opo, so far in our estimate, okay pa naman po.
Madam Chair, I saw in the last slide, no, 60 cases for promulgation, 40 new cases. This is virtually almost one or two cases every month in the next 60 days. Is this every day? Is this feasible?
Yes po, because every commission meeting, we are able to take up about 5 to 10, depending on the length of the presentation. What we did during the vacation, we fast-track the technical evaluation so that, and most of the 60 have already, we are done with the technical evaluation. So these are now being reviewed, and it will be easier for the commission to act on this because we have done our CSW.
So in other words po, you thought ahead, and then all of the things necessary to make them decide, to evaluate, has already been completed. So magdidesisyon na lang po yung commission. No?
Yes, Chair. And actually po, also to handle some admin matters, our policy now is when the service, when our people present the case to the commission, they have their memo and they have their draft resolution based on their memo. So that if there are no changes, it's going to be easy for us to just sign it until the following day. And if there are changes, then anyway, they have the soft copy, they do the changes so that we can dispose of them also within the week at least, at most.
Thank you, Madam Chair. And would like to hear from the stakeholders. I know si Attorney Annie raised this last time. That's why this came about. Sa PIPA, any reaction to the updates?
Good morning, Mr. Chair. Yes, PIPA is very supportive of the ERC. We welcome the updates. Actually, I will be sending an update to the Board of Trustees later. And I am sure that the ERC, of course, has PIPA's support with regard to settling all the issues. And we look forward to the resolution of the cases, the 60 cases, for sure, because it will affect most of our members.
Again, itong mga approvals and will be approved, itong mga approvals and the ones that will be approved, is this sufficient already to cover the necessities for the summer months?
Well, Mr. Chair, we take it day by day. So for now, this is good news. And then, so for now, this is good news. So we welcome this good news, at least Valentine's. So, and then we'll work on it as
give us
proceed.
feedback, no,
Yes, sir.
regarding this. So we just want to make sure that come summer, wala tayong
It will be
problema. And you have
sufficient.
members all over the country. No? So we might have overlooked some of the documentation. Please give us feedback.
Definitely, Mr. Chair.
And Raymond, I read your press release 2 days ago. I think RESA issued a press release that some of your members, some of the licenses, no, or certificates of your members will be expiring. So can you give us some updates on that?
Good morning, Mr. Chair. So we appreciate the update also by the Commission, especially on the switching rules and disconnection rules. However, we're also affected by another case at the Supreme Court. But the immediate need for us is really the 7 members who have expired licenses already. At the PMC level, they issued some mitigating measure to allow, prior to this move by the Commission, to allow continued operation of plants without COC. So we're trying to look for something similar so that the members of the 7 members who are serving contestable customers right now may continue to operate, given that the situation with the Supreme Court is really something that, and I think
That's beyond the ERC's ambit already, because the whole reason why you cannot renew your licenses because of that TRO, hindi because of the suspension. Tama?
yes, sir, to a certain extent, but we're still trying to hope, because if, well, the way we understood the TRO of the Supreme Court, it's purely for the mandatory implementation. Although the resolutions included those pertaining to the issuances of licenses, it wasn't, well, we feel, I'm not a lawyer, but we feel that the statement of the TRO did not include the suspension of license issuance.
Well, we urge ERC to look into that, because I know a lot of contestable customers are already using the rest. No, but I know for a fact that some of the rest has been selling power already.
Yes, I think of the entities that are the rest entities that have contracts, the 7 represent at least 38% already of, or almost 40% of that.
Kung hindi sila ma-renew, ano mangyayari?
It's like driving without license, Your Honor.
Hindi, but they will cease operation. But those contestable, can they? Ano mangyayari sa kanila?
Well, there are options for the contestables to continue, but in essence, it's the rest entity that have expired licenses that will be penalized by the Commission for continuing to operate.
Continue to sell, pero wala silang license, so meron silang penalty. Ganun ba yung...
Technically, bawal po talaga eh. It's not really allowed in the guidelines that to operate without a license. However, some have contracts that were beyond the license term, no? So that's what we're hoping to address at the very least, that these entities with still valid contracts.
But can the contestable go straight to the GENCO? Will the GENCO honor whatever the rest and the contestable entered into?
If the generator has no rest license, they cannot do that. And that's our view of how the supply sector should operate.
We just want to urge, ma'am, to take a look at this. Commissioner Asirit, do you have any?
Yes, well, actually, sir, that actually is a subject of another Supreme Court case, and unfortunately, under pain of being held in contempt, the ERC's hands are actually tied. What happens now is that for all those whose licenses have expired, for the retail electricity suppliers whose licenses have expired, they cannot sell. That's really what's going to happen. Their customers will have to move to another retail electricity supplier who still has a valid license, and that actually contracts the number of available suppliers, which defeats the very purpose of having retail competition and open access. But we have actually already filed a manifestation and motion last December with the Supreme Court through the OSG for the lifting of the TRO, and alternatively for a clarification as to what the TRO actually should only encompass. So we're hoping that that would also be forthcoming soon, at least even just a clarification from the Supreme Court.
Commissioner, if the TRO will be prolonged, the license rest will dwindle over time kasi hindi
Yes.
sila nare-renew, di ba?
Yes, sir.
So, what will happen now to the contestable? Ano ang pwedeng gawin ng contestable customers?
Well, actually, the contestable customer will have to move to another retail electricity supplier, or will be
Assuming
going back
maubos
to
sila,
his... Wala na, sir. They will go back to their local...
captive,
Yes.
to your local distributor.
yes. Solar. It's called a supplier of last,
Last
resort,
resort,
which is
oh.
actually a distribution utility, designated as such, but at a premium.
Mas mataas yung ano niya, no? Again, that's another issue that we need to resolve, but that's again a side issue from the suspension issue. Any comments regarding the updates from the stakeholders? Paul, do you have any comments from the ECs?
Thank you, Mr. Chair. The ECs would still, we welcome the press release recently of the ERC wherein they will look into the pending cases. Particularly, we look forward to approval of capex plans of our member consumers, our member ECs, since this will redound to the benefit of our member consumers. Be that as it may, since we are discussing the ERC governance bill, we reiterate our stand that perhaps we would like to invite this committee to explore the possibility of having empowering divisions of the ERC in Luzon, Visayas, and Mindanao, so that those who are in the provinces or outside of Metro Manila will have easier access to the ERC, wherein decisions, wherein hopefully speedier disposition of cases may be arrived at. I think we are at a peculiar position to ask this body to consider, since we are the National Association of Electric Cooperatives, and the other stakeholders do not have such position such as ours do. So thank you, Mr. Chair. We reiterate our support for this bill, and we look forward to submitting our detailed position paper, which we are still in the process of crafting. Thank you.
Thank you, Paul. Any last comments before we leave the updates? Attorney Nino.
Thank you, Mr. Chair. From PEMC, we actually welcome this development as far as the approvals of the COCs, both for the existing and for the new capacities. So at least we would not go into the issues that we anticipated we will face when we implement the earlier PEM board resolution that was issued. May I just also just flag an issue for the market, which is the pending price determination methodology filing for the market to be able to implement already the new market management system. Our existing market management system has been there for more than 12 years already, and we don't know how long still it can last in terms of the operations. And the new MMS certification, audit certification, will be completed by middle of the year, and we will just await the disposition on our current PDM filing, so we can already roll out this NMMS for the market, both for Luzon and Visayas, and thereafter for Mindanao also.
Attorney Nino. Commissioner.
Just as an update on that, the expository presentations have actually been completed, if I'm not mistaken, for Luzon, Visayas, and Mindanao. So the next steps would be the subsequent preliminary conference evidentiary hearings, likewise following procedure. So yun, sir, matutuloy na yan, because then the hearings can already be scheduled and will actually be followed through.
Thank you, Commissioner. And I think that's also one reason why the Office of the President had a difficult time in looking for acting commissioners, because yung sinabi ho ni Attorney Juan parang pang outer space no? To be honest, if you're not really into the power sector, it's very difficult to learn the intricacies. I mean, it's easy to ask questions about brownouts, but going deeper, especially what Attorney Nino mentioned, that will take years to master or to even understand. No? So it's really hard. The learning curve is quite steep. So, appointing someone for 6 months or 1 year, it's really it's not rational, or to some people it might not be so worth it. No? So that's why I think that was a very difficult task for the Office of the President. Nevertheless, for now, I think it's well established that in the next 2 months at least, until when the summer season will come in, hindi ho tayo magkakaroon ng brownouts. I think that was also consistent to what Department of Energy mentioned in some of its press releases and also its comments during the last hearing. But Attorney Arquisa, please submit to us an official computation, no, for the next 2 months and the next 6 months from today. Take into account the updates from ERC, no. I'm sure ngayon nyo lang ho nakita to, no, or ewan ko na-furnish ho kayo. But there are numbers here. There are capacities that were mentioned, and we want to make sure na itong mga capacities nakabangga ho to sa forecast natin in the next 2 months. Again, the objective here is to assure consumers, assure businesses that we will have power even during the peak of the summer. No? And the peak of the summer is always a worrisome event for many of us. So we want to make sure that nakabangga ho to doon sa forecast ho natin. No?
We'll do that, Mr. Chair.
Thank you,
And by the
Attorney.
way, we've been in constant communication with the chair.
All right. Thank you, Attorney Urquiza. With that, we'll go to the discussion on the bill. I think we have covered the updates from ERC. And to go into SBN 1490, or the ERC Governance Reform Act, ERC submitted us an extensive position paper, Madam Chair. Can you please discuss in brief, no, the most important points there? I know mayroong mga discussion there na mahaba eh. No? So alam ko importante yon. Please elaborate to us your position on the most important points so we can discuss it freely in this hearing.
The first, Your Honor, is on the delineation of function between the chairman as and CEO and the executive director. And we stated in our position paper that we are proposing that the chairman shall maintain the position of CEO, Chief Executive Officer, while the Executive Director shall be tasked as the COO to take care of the day-to-day functions and problems. Why should the chair remain to be the Chief Executive Officer? It's because the commission is a small body. Together with the increased plantelia positions approved by DBM, we're just about a little bit more than 300. So that anything that has to do with the regulatory function of the ERC should have the chair as the executive chief, as the Chief Executive Officer. Insofar as admin concerns are, then it should be the Executive Director. So, what are the regulatory functions? Anything that has to do with the cases, because then the chair will be able to direct even the systems of how we can fast track the resolution of the cases. We cannot totally divorce the chairman from the rest of the officials of ERC, because like for example, we have the different services, the technical services that make a study. Then the chair, as the Chief Executive Officer, must be able to really monitor. And there is an administrative component insofar as supervision over these technical services are concerned. But insofar as administrative concerns like procurement, HR, human resource, trainings, all this can be undertaken and more effectively by the Executive Director as COO. So that's the other is the deliberative process privilege. Your Honor, in the proposed bill, there is here there is a provision which says that all meetings shall be open to the public. In processing all the applications, we have public consultations, we have public hearings. However, after all the results of the public hearings are summed up, including the technical, there should be a deliberative process by the Commission that should not be open to the public because, Your Honor, just like the Senate and most of the government offices, we are given that privilege to make the deliberations outside of the observations of the public. For example, Your Honor, one of the members of the Commission can be, so to speak, the devil's advocate, so that we will be able to see all the angles in a particular application or particular subject matter. And if this will be open to the public, we may be misquoted and taken out of context. And there will also be a tendency that we will just say what is popular. Tendency. It's human nature that we would not like to invite the ire of anyone, especially if the public is there. But in terms of a very thorough deliberation, I believe that the Commission must be left alone. We do the deliberation, of course, with our technical people, and there are exchanges. So the other one, Your Honor, is well, those are the highlights. Of course, we have also submitted as part of our position the retention of our earnings, which, for example, right now, Your Honor, we are not able to hire lawyers. We can hardly hire lawyers because we cannot even compete with the compensation package of the lawyers recruited by OSG, DOJ, and PAO, and SEC, for that matter. So if only we can have all the lawyers that we need in accordance with our plantilla positions. Right now, we still need about 25. Then the 60 target for 60 days can definitely be increased. So that's our problem. So it's really, one is the retention of our earnings. Not, of course, we know that it's going to be just about 20%. And then the other is the increased compensation package. And for the retention of the revenues, a portion of it, we always need, Your Honor, technical consultants. The rules that we are promulgating are actually the results of studies presented by our technical consultants. We cannot do it just among ourselves, not even just about consultations, because the technical consultants even take note of the practices and policies in foreign jurisdiction. And for this, we don't have people who can devote the time. So we are in dire need of all those.
Thank you, Madam Chair. Madam Chair, right now, for the information everyone, right now the role of the chair is chair and CEO.
Yes, Your Honor.
Okay, and then there's an ED. That's how the structure.
Yes, Your Honor.
Okay. But in your proposal, the chair and CEO remains, and then the ED will be given a COO role.
Yes, Your Honor.
How do you now differentiate the CEO and the COO role?
The CEO will have to function, will have to discharge duties on matters related to the core function of ERC, which is rate fixing. So, or rate setting, I'm sorry. it's not fixing, baka mabigay na kung ano eh. Rate setting po. Yun po yung core function ng ERC. So, lahat po na related dito, dito sa function ng chair as part of as in terms of regulation, should be retained by her. I did a run of this concept during the vacations. And I saw that it can work better for ERC. I just dealt with more on the regulatory services, the market operations services, the legal, and I gave 80% of my attention to this, even going down to their offices, just to chart even the administrative flow of decision making, the processes, the business process operations, something of the sort. And I think we were able to succeed because right now, as I said, we were able to fast track the technical. But if at the present, with the chair as also the CEO, that other 20% had to be devoted to approval of leaves, approval of travel authority, scheduling of training, scheduling of selection. You know, we can dispense with that. And as I said, almost inspecting the physical facilities, including CR. You know, let's give that to some others. And making sure that we take care of our personnel is something that the CEO should focus on. So, and of course, the ED will have to do probably he will have to coordinate some of the activities, but it's more of the chair doing it for the regulatory functions.
Madam Chair, so let me just break down some of the functions. Like for example, in the present setup right now, ang chairman and CEO, siya po yung nag-a-appoint ng ED. Tama po ba?
Opo, at saka
Siya lang.
lahat.
Siya lang,
Lahat.
no?
With the commission, of course, because yung level po ng director, commission po yun eh.
The
Pero
entire
lahat
commission.
yung below, kami na po,
So,
sa chairperson po yun.
So ano po yung mga ina-appoint ng commission level, at the commission level?
Yung pong head ng different services, yung level na yon.
And
Kasi
then-
very critical po yun.
Okay.
Oo, so, at saka we do the selection because if it will be the level of the directors or the directors themselves choosing, so it may not be that productive. Unlike the commission, when all of us are really not in competition with any of them. So that's the delineation.
So the commission, as a body, appoints the ED
Opo.
and appoints the heads.
Opo. The
And,
directors po.
And when you say appoint, you deliberate and you vote.
Yes po.
Okay.
We vet.
You vet and
Yes
then
po.
you vote also.
May interview pa po yan.
Okay.
Oo. So, ganun po yung proseso at present.
Okay.
And I think this can still be retained under the proposed
So
bill.
the chairman and CEO cannot unilaterally appoint an ED
Ay, hindi po.
or any of the heads.
Hindi po. Hindi
So
po talaga.
that's a very clear
Opo. Very,
uh,
very,
procedure.
Opo.
No? And then when it comes to budgeting, for example, when you propose your budget here, is this also a deliberative process?
Well, right now, we instituted a practice, a process, that each service will have to come up with their own budget proposal. That shall cover training, transpo, supplies, and all those things. And they are presented. We have the heads, meeting of the heads, and they present this to the meeting of the heads and practically to the commission because we are present. So the process really is something that is bottoms up. The first, of course, was a seminar for them, and we got people from DBM to give us the guide and the inputs.
Yung entire budget po, before it's submitted to Congress or to the Senate for this matter,
Commission po.
Commission din.
Commission
so the
po.
commission signs off, for example,
Opo, opo. Opo.
for 2019, it will be 400
Yes.
million and all the
Opo.
commissioner signs.
Opo, opo.
Okay.
Opo.
And you debate na, ito dapat,
Aha, aha.
Tanggalin,
But that
ito
is
lipat.
discussed in the commission.
okay.
Hindi ho pwedeng chair lang, although usually chair lang yung pipirma, but it is by authority of the commission.
Okay. And the administrative functions, like for example po, yung sinabi niyo, hiring and for example, suspension of employees, suspension, is that meron pang board, ano ho yan? Is aakyat na ho yan sa
Meron po
commission?
kaming kinreate ngayon na body, pero syempre po, it is reported to the commission and the chair is usually given the task of signing the suspension orders.
Mga hiring,
Pati po hiring,
so,
yun yung mabigat po
so
para
lahat
sa
po, all the
amin
way
eh.
to, let's say, the clerk, the
Opo.
chair is the one
Opo,
hiring that.
dinedelegate po kasi yan eh, sa chair lang po. So we have the Personnel Selection Board, the PSB. They do the process, interview and all, and brought up to the commission and the chair signs. On the other
Only
hand,
to the chair, not to the commission anymore.
to the commission po. Pero
But
chair actually, the practice is it's brought to the commission, but in reality, below the directors, the chair signs the engagement.
So that's ano na ho yan, the chair has the say whether
Oho.
that person will be hired
Oho,
or fired.
like job orders, lahat po yan, chair pa eh.
Ganun rin po, suspension,
Mhm.
disciplinary action,
Opo.
chair ho lahat yun.
Kaya kung matatanggal po yan, eh di mas marami po talagang cases kaming masosolve.
But not as a body na. For example, kung meron pong disciplinary, for example,
Ay,
ang
hindi na
isang
po.
clerk, nag-awol, aakyat pa ba ho yun sa commission para i-deliberate?
Ang practice actually, hindi naman deliberation report.
Report lang.
Report lang
Oo.
po.
But the chair ang nagpumaperma
Talagang chair
for
yung
dismissal
responsible
or
for
suspension.
that. Opo.
Okay. Kanina, Chair, you mentioned also yung purchasing functions, which is a very important, ano?
Yes po, yung back.
Okay.
But as head of office, I will still have, the chair still has to sign as head of office as required by the procurement law.
But the back is independent, no?
Well, yes, it's not the commission. We have set of officials. However, we can
But the
We-
purchases before the back
from
before the back is triggered to do its own procedure, it's only sino ho ang pumiperma? Chair
sa
lang?
services po, meron pong purchase request. So it's the usual process in other government agencies. The PR is done by the service that is
Pag capital outlay.
concerned. Eh kung nasa kanya pong budget, because di po ba
Okay.
meron tayong annual procurement
Plan,
plan.
yes.
So it's by service.
Okay.
So when it's time, and DBM is very strict now.
Mm.
You just have to submit to them the things to be procured for the quarter.
So if it's inside the annual procurement plan,
Opo.
hindi na aakyat ho sa commission yan.
Approved na po yung annual procurement plan.
Yun na lang, yung plan nilang ay
Opo.
approve ng commission. But the
Parang
plan,
kukunin na lang, huhugutin na lang dun sa
yes,
annual
oo.
procurement
But the plan is approved by the body.
Opo.
Okay.
Opo. It has to be.
So in your proposal, now I understand, no, the present setup. In your proposal, which one do you want to delegate to the CUO?
Nasa ba yung detailed natin? Well, for example, the functions, the duties and responsibilities assigned to the financial and administrative services, the ito po yung we actually submitted, which is our Annex D. So and we have a matrix for this. So for the duties of the executive director, acting as the chief operating officer, we have the preparation of the budget of the agency will have to be handled by him for presentation, of course, to the commission. And then the supervision, recommendation of procurement projects, the implementation of internal policies of the organization, and of course to direct, manage, and supervise the day-to-day operations and internal administration of the organizations in accordance with the policies laid down by the CEO. And usually our policies are approved by the commission and then implemented by the COO. So from these policies will now be for implementation, supervision by the COO. And of course, the coordination and supervision of activities of the different services, which are not really the core function of the commission. We also also this one, all the training programs and all the enhancement of ERC staff, even, Your Honor, the coordination, let's say, with our technical consultants, because once we have engaged, they usually go back to ERC for some more data. So these things may be given to the COO already. In other words, it is the preparation, supervision, and management and overseeing of all the preparations of documents and subject matter to be presented to the commission.
Madam Chair, my observation, especially during the time of your predecessor, from my observation and from what I read in the papers and also the deliberations in the other bodies, I realize I have this analysis that the your predecessor had a lot of power, no? Even powers that are supposed to be a deliberative in process. No? I had this impression that he controls everything, no? And the commission, sila Commissioner Asirit, is just limited to rate approvals. But the rest, no? Meaning the appointive, the administrative, the budgeting, no? All of this is delegated to one person, which is the chairman and the CEO. So he becomes very powerful, no? In fact, if you can appoint the directors, ikaw lang makaka-appoint, anything that comes out of the directors, you have a lot of influence, no? So that is my impression from what I read and from what I hear, and also from what my interviews with the stakeholders. Because of that vast powers, it gave rise to abuse, no? And I won't go into the merits of that abuse, but definitely there was some form of abuse, no? That's why all of these things came about. And my analysis there is because the balance of power, which is vested in the commission, was limited to one person or was concised into one person. Naging sobrang lakas niya. No? And the problem with that is that person is only beholden to the president, who is the appointing authority. And the president, we all know, has thousands or hundreds of people he appoints. So no, he cannot monitor each and every one. No? The concept really of a lot of the best practices in terms of governance is a self-governance mechanism
Yes.
in which the entity governs by itself. It has a mechanism to remove top officials. It has mechanisms to reprimand top officials. And the balance of power is equal. Importante. I believe really there should be a balance of power. But in my impression in the past, and again from my readings, na concentrate siya into one single person. In this case, one person talaga. No? What can you say about that? Is that your observation, or was ano ba ho ang nangyari in the past? No?
Baka ho interpretation. Interpretation na as presently worded, when you are the CEO and the chair, sa'yo lahat, ikaw lang. Pero pag binasa po natin yung existing laws, hindi naman po ganon. Like, even if you're the chair, you cannot undermine the bank and just issue out orders. Kasi dapat commission, collegial body nga eh. Even the interpretation alone of the nature of ERC as a collegial body runs counter to an interpretation that the CEO is the sole powerful person in ERC. That's why I cited the annual procurement plan, the budget. These are all to be approved by the commission because it is, when we say commission, it's not the chair. Now, another point, Your Honor, is that on personnel, if there is a COO, the one who will be evaluating will be the COO already from below the director level. So ito ho yung check and balance. And if we give the emphasis that the CEO the CEO functions will be related to the technical and regulatory functions of ERC, then I think we can see that there is a division. On the other hand, Your Honor, I'm afraid that if we have a very strong personality executive director being the CEO, there may be another interpretation which can be that kind of interpretation. So that if you have the COO and the CEO, immediately the concept is there is a check and balance.
Correct me if I'm wrong, Commissioner Asirit. I don't know if my observation and my my analysis is wrong, pero parang ganunin na what I understand, even the budget is not deliberated, no? It's purely in the hands of the chairman and CEO.
That was what was happened previously, sir, but it should not have been. I think
And
that's
how
what we're
come it
trying
happened?
to correct there.
And because of that interpretation.
I believe so, sir. Because when we see the budget, it's already done.
So one person interpreted the law to his own
Well,
benefit.
I'm not sure I am the proper person to.
No, I'm just parang from again, no. Si Nino was a former ED also. You know? Totoo lang eh. No.
Sir,
What I'm hearing from
I-
the chair now, from Madam Chair,
Yeah.
is a totally different
Yes.
setup
Yes,
from
sir.
what I have observed,
Yes, sir.
what I have investigated,
Yes.
and what I have analyzed.
Yes.
Malayong malayo.
Yes,
It's
sir.
really worlds apart, no, from what the Madam Chair is saying. No?
And
Ewan ko kung ako lang ang nag-misinterpret or...
so I believe that moving forward, that would be the best, perhaps procedure or way to go to be able to institutionalize the governance structure at the very least. There will always be issues in terms of personalities, no matter how perhaps well defined a structure would be, and that's precisely why the check and balance is necessary and must be known also to those who are actually sitting in the positions of responsibility. I think that's where somewhere along the way something was lost in the interpretation, which led unfortunately to where it brought the ERC. But moving forward, the lessons have been learned. We're trying to move as best as we can with the structure that is currently in place, putting as much transparency and participation by all commissioners, and also likewise even the directors, because previously the directors did not even have that much perhaps information regarding the budget that was actually allocated or allotted to their services.
Any comment as a former ED, not as a PEMC COO, but a former ED. Now I want to pick your brains. So,
Sir, before the former ED shares, I'd like to share also that during the time of the former ED, we did not have much issues, to say the least.
as a former ED, not as a PEMC COO, any comment? Kasi totoo lang, ma'am, what you mentioned earlier, I was very surprised because all of those I ask are those are the I call it pressure points, no? If you control the budget, if you control the personnel, no? In fact, when I was working in the private sector, I'm always appointed as the finance and administrative spy, so to speak, in our family business. Kasi yan ang pressure points. If you control the money, if you control the personnel, you control the organization. And from what I gathered in the past, the former chair controlled that. Therefore, he controlled everything. Because if you appoint the key personnel, obviously the loyalty is to you. But what you were saying earlier, it's a deliberative process, which I didn't gather from the past. Nino, any comments? Ikaw, you've been there for a while, so...
I think ever since, Mr. Chair, that has been experienced not only in the immediately preceding chair of the ERC, but in the case of former chairman, there had been some issues on the interpretation of the extent of the authority of the chair as CEO. So perhaps the best way forward would be to define really the parameters of that CEO function that was entrusted by law to the chair, so that there will be no misunderstanding in the future as regards the role of the chair versus the other members of the commission, and also as well as the function of the ED. I remember during my time that my job description was really just that general, which is to oversee supervise the different departments, and also perform such other functions as may be assigned by the CEO. So I worked on the basis of that description. So maybe perhaps as what Chair Agnes was saying, maybe it's an issue of interpretation. But if we can address that by providing some details of what that should be, what the correct interpretation should be, then perhaps we can avoid the same misunderstanding in the future.
I can't believe that all of this fiasco happened because of interpretation or misinterpretation for this matter. So, parang nakagulat lang na all of this came about because someone was interpreting the law to his own liking. And moving forward, Madam Chair, what's your suggestion? If interpretation is the root cause of all of this, how do we move forward?
Well, I I agree with the point emphasized by ano ito, commissioner o ED? Nino. That based on experience, we cannot allow the provision on the CEO subject matter be have room for interpretation. And therefore, we do a delineation of the CEO, chair as CEO, and ED as COO. And we have listed down some of the things that we think can be no more interpretation. It will just be a litany of exactly what can you do as CEO, what the COO can also do. So the cutting edge there is it related to the regulatory function of ERC? Then it's with CEO. Is it related to the administrative function of the ERC? Then it's the COO. Well, of course, easier said than done, but we can do the list of what can be done. There may be gray areas, but the gray areas can be easily, I think, interpreted by going through the list, and therefore it cannot be, the gray area cannot be, cannot exceed the express list of duties of a COO and CEO.
In the I know ERZ is a regulatory body, but it has some characteristics of a corporation or a listed corporation. And in November of 2016, the SEC came out with a code of corporate governance for publicly listed companies, in which on page 25 it mentioned one of the recommendation, no? The positions of chairman of the board and chief executive officer should be held by separate individuals, and each should have clearly defined responsibilities. No? We're actually looking at different best practices. I know that ERC is a different entity compared to a publicly listed company or typical corporation. No? But in many of the recommendations for good governance right now, or good corporate governance, it's really separate. But I think if the chair is proposing to really itemize the responsibilities of the CEO and CEO, thereby clearing the two responsibilities, then I think that is a workable solution. Ang ayaw nga natin is, from what I hear, is an interpretation. And because in fairness to the stakeholders, ang gusto naman nila is certainty and stability. That's it. What they want is a perpetual stability in the regulator, so that when they invest, alam nila na makukuha nila yung investment nila at the at one point. And also to the consumers, they know that the interest of the consumers is always being protected. So with that, we're quite blessed to be joined by one of the members of B Leaders. Mr. Michael Pitlock is, if I understand it correctly, was a member of a regulator in the U.S. Michael, can you state for the record your past experience, your past your history in regulation, and can you give us comments regarding the discussions earlier?
Yes, Your Honor. I started in the regulatory process in 1979 as a member of what was then the Nevada Public Service Commission. I worked my way up through the staff to the position of Director of Regulatory Operations, which is the same as the Executive Director level at the ERC. After serving in that capacity, the governor appointed me to my first term as a commissioner. I ended up over an 8-year period serving 3 different terms under 3 different governors before I left state service in 1999. Since that time, I've been providing technical assistance through different USAID programs, mostly in Asia, and mostly here in the Philippines, spending a lot of time as an advisor to the ERC. If it please the chair, I'd like to share a little bit of my experience as a commissioner in Nevada and highlight 3 areas that are different than what the ERC does here in the Philippines. The first one I'd like to talk about, and it relates to some of the governance issues with respect to the duties of the chair versus the duties of the executive director. In Nevada, the staff was separate from the commission. And when I say that, they were separate in terms of the regulatory process. In a hearing, the staff was a separate party to the proceeding. They would present their own witnesses, they would cross-examine the other witnesses, they would present their case in the public hearing. They would not communicate directly with the commissioners. That would be governed by ex-parte communication rules, just like any other party to a proceeding. So because of that separation, the Director of Regulatory Operations, or the Executive Director, had full control over the staff in terms of the administrative process, in terms of hiring and firing and directing the activities of the staff. They were an independent party in all the proceedings. On the commission side, they had policy advisors, so they had their own staff, a much smaller staff, that they were responsible for the hiring and firing and discipline of, that would give them technical advice. So because the role of the staff was so different in the proceedings, the administration of the agency was also different and was bifurcated between the commission side and the regulatory operations staff side. With respect to deliberations, Nevada has an open meeting law. All meetings of the commission where a quorum is present and they're discussing pending cases had to be noticed and open to the public. Now, during my 3 terms at the commission, part of the time we were a 5-member commission. When we were a 5-member commission, because it took 3 members to form a quorum, we could have one-on-one discussions between commissioners as long as it was just 2 of us. Towards the latter part of my term, we were reduced down to a 3-member commission. Under a 3-member commission, we still were subject to the open meeting law, which meant that 2 of us could not discuss pending matters unless it was in a noticed public meeting. So all deliberations on contested cases were done in public. And because the staff was an independent party, what was deliberated on was the full record of the proceeding, because the staff's position became part of the record. The practice here is the staff makes their recommendations to the commission in a commission meeting. So that part would be dramatically different if the staff was a separate party. It's been my experience, when you look at the personalities of most people that are appointed to positions like a commissioner, they're not shy about expressing their opinions. Whether the cameras are there or the public is there, no matter who's there, they will express how they feel about the pending issues in front of them. And so I never saw any problem in the deliberation process simply because we were required to follow the open meeting law. The third point I'd like to make about the regulatory process, and it has to do with the involvement of consumers. In the state of Nevada, as part of the Attorney General's office, there's the Office of the Consumer Advocate. The consumer advocate under law is given the authority to represent residential and small consumers before the ERC. So they would also be a separate party to every proceeding. So in a typical rate case, for example, you would have the utility presenting their case. You would have the consumer advocate calling his own expert witnesses, cross-examining the other witnesses, and presenting his case. And then you would have the staff presenting their witnesses, cross-examining the other witnesses. So the record is a full picture of all sides. And so the completeness of that record, I think, helps the deliberation process, and it makes it easier for the commission to deliberate technical issues without having to do it in a closed session. Now, even under the open meeting law, we were allowed to go into executive session. For example, if we were discussing personnel issues, or we were discussing confidential information that was presented to us through the hearing process. So there are exceptions.
Sorry, Michael, to cut you. We recognize the President of Senator Sonny Trillanes. Go ahead, Michael.
So I guess the bottom line is I've seen the process work both ways. There are many agencies around the world, regulatory agencies, that are structured like the ERC. There's also a lot of agencies that are structured similar to what the Nevada Public Utilities Commission is structured. Both can work, assuming you get the right people to be the commissioners. The last thing I'd like to say is, and no offense to any existing commissioners or past commissioners, including myself, but commissioners come and go. The stability of the agency lies with the staff, not with the commission, because commissioners come and go all the time, whether it's in the U.S. or any other jurisdiction around the world. The important players for consistency and reliability are the staff. Thank you.
Thank you, Michael. Thank you for sharing your experience in the Nevada regulator, state regulator. Just a question. No? We're talking about the structure, no? And this is the internal structure of ERC. I just want to understand some more. How is the Nevada regulator, the one you mentioned earlier, structured in terms of balance of power between the staff or the administrative staff and also the commissioners? How is it structured? What is the relationship between the two levels?
Because of the role that the staff played, there was a clear division between the administration of the staff side of the agency and the commission side of the agency. The Director of Regulatory Operations, which is the equivalent of the Executive Director, basically made all decisions with respect to personnel, hiring and firing and directing of the regulatory operations staff. On the commission side, it was a collegial body. We didn't have a designated chief executive officer. All decisions on the commission side of the agency were made in a deliberative process by all the commissioners. Now, agency-wide issues, for example, the budget, was done on a, a bottom-up basis. Each one of the departments on the staff side would make their recommendations to the Director of Regulatory Operations. He would put together the staff side budget that would be presented to the commission. The commission then would add to that the recommendations for the commission side of the agency, and then the commission, through the chairman and through the commissioners, we would go to the state legislature and present the budget. The budgeting process in Nevada for the commission was somewhat different in that we had a dedicated funding source. We had an assessment on every utility bill that went into a fund, and that fund could only be used for the commission or the consumer advocate, part of the Attorney General's office. Now, the state legislature still approved our budget, but the difference was we didn't have to compete with other state agencies. For example, we didn't have to compete with corrections or with health or with education because we had our own funding source. But the legislature still had to approve the budget.
The commission, at the commission level, it does not, who appoints the ED?
The commission.
The commission appoints the ED.
That's the only position on the staff side that is impacted by the commission itself.
How about key directors? Who appoints them?
The ED.
The ED. So it's only the ED that the commission appoints.
That's correct.
Okay.
And again, it goes back to the role that that staff plays. They're an independent party in the cases subject to ex parte communication rules, so the commission should not be involved in directing them or hiring them based on a certain philosophy they may have about utility regulation. They're supposed to be independent from the commission.
So in other words, the staff should be able to defend their case independently.
Exactly. They're a party to the case. They have to put on witnesses. Their witnesses are subject to cross-examination. That testimony and cross-examination becomes part of the record of the case. The record of the case is then used in the deliberation process, and should there be an appeal of that decision to the court, that entire record from the hearing, including the participation of the staff, would go up to the court.
And the Office of the Consumer Advocate represents the consumer.
Yeah, under the law, the consumer advocate is authorized to represent the residential class and other small consumers. In the state of Nevada, the major customers normally would intervene in a case and they would represent themselves. But in order to have a high level of advocacy for the residential class, the state legislature decided they needed a professional entity to do that. Because, as we all know, the power sector and many other public utilities are very technical, very complicated. And so the consumer advocate had a fund where he could hire the technical consultants and come in and put on expert testimony representing the point of view of the small and residential customers.
Michael, earlier you also mentioned open meetings, and I think this is also one request of the consumer advocates. Many of the consumers, I remember talking to a consumer group, and they were telling me that they want to argue, but they don't know, but they don't understand. No? All they understand is they cannot pay the rates and the rates are too high. But in terms of computation, in terms of arriving to that particular rate, they don't understand it. And partly because they don't know the discussions in the that led to the approval of the rate, or that led to that computation of the rate. So can you elaborate further the concept of open meetings?
Well, first of all, with respect to the consumer advocate, having the office within the Attorney General and having a budget specifically set aside for representing residential customers, they were represented at a very high level from the very beginning. They were automatically a party in every proceeding. Expert witnesses would be brought in to testify. With respect to the open meeting deliberations, one of the challenges that every commissioner faces, whether it was in Nevada, here in the Philippines, or in every other jurisdiction around the world, is to try to help the general public understand very complex technical issues. The more open you are, the more those discussions take place in the sunshine, the more credibility the discussion will have. And we found that to be true in Nevada. Even some of the staunchest opponents of rate cases, if you had an opportunity to explain to them the rationale, explain to them the different sides of the issue that was presented in the hearing, and why you chose a particular path, the ability to communicate that increases the credibility of the decision tremendously. And every utility regulator in every jurisdiction, credibility is essential, because the general public tends to mistrust government, and they mistrust government even more when it's done behind closed doors. So trying to overcome that built-in mistrust requires a great deal of credibility to be increased. And that's one of the things that I learned as a commissioner in Nevada. Another thing that we would do with respect to consumers is we would hold consumer sessions. We would hold them in the evening, so people were off work, they would be able to come. If it was a pending rate case, we would invite representatives from the company, and we would simply open the floor to any comments that the public would want to make. And I can tell you that in the past, I spent hours in front of very angry people in Las Vegas complaining about their power bills. But at the end of the day, when you talk to them one-on-one, just the fact that you let them speak, you gave them an opportunity to vent, you gave them an opportunity to present their opinion in front of the commission, in front of the company, they felt better about the process. They felt like they were included in the process. If you include them in the process, chances are they're not going to mistrust the outcome.
There are instances where the deliberations are not not held in public? Are there instances or are there processes there that are exclusively close to the commission?
The only time that we would be able to go into executive session is if it was dealing with, number one, a personnel matter, or information that the commission had deemed to be confidential for some commercial reason.
Topic of open meetings. Madam Chair, I just want to understand, again, for the information of everyone, a simple process on how to, a simple process when you approve rates. No?
Okay.
Ano po yung step 1, step 2, until it reaches the commission level? No? Ano po yung mga process?
May I ask Commissioner Astrid?
So the first step actually would be a pre-filing conference before the actual application is lodged before the commission. In that pre-filing conference, we have a technical working group that checks, assists the applicant on the documentation process. Once that is filed, the legal service now will set that case for an initial hearing. In that initial hearing order will include, of course, the publication, furnishing copies.
Sorry, Commissioner, the pre-filing conference is open to the public? Or you just invite the parties?
It's just the parties because there's no application yet. It's looking over the documentation,
it's just
the
within-
the submissions will be
So this is-
pre-filing.
So this is
pre-filing.
within the
Yes,
the,
within the
ERC.
Within the ERC. Once that application is filed, that's when they submit their the requirements on posting. So wherever the application is going to have an impact, whether the jurisdiction of the distribution utility or electric cooperative will be, then there are requirements for posting, etc. Those are submitted together with the application to show that there has been that posting. And then an initial order for the setting of the case, for the hearing, is then issued by the commission. This is now the public hearing. In that public hearing, this is posted, the date, and then notices are also given to the in the area where it will be, where the application is going to affect the consumers. That hearing is public. It's presided over by a lawyer from the commission or one or two of the commissioners, or sometimes even probably, if needed, the entire commission and bank. The first step is called the expository presentation. The expository presentation is a presentation made by the applicant to explain what the case is all about. Normally, what we do is that, and this is in the area, in the place where the application is going to affect the consumer. So if it's going to be for Leyte, so whichever cooperative is the counterparty, then it will be in that particular area, at least for the first hearing. Okay. In that what we call the expository presentation, an explanation is made on what the application is all about. If it were a power supply agreement, both the electric utility and the generation company will make presentations. while it can often be very technical, the Commission endeavors to bring the presentation to the level of understanding of the consumers, because invited to this, the electric cooperative is required to invite and include media and its consumer groups or councils, associations that would have a that would be directly affected. So consumer groups, business associations, more often than not, legislative representatives from the local legislative councils. In that expository presentation, the parties are now subjected to a Q&A by the commission, by the technical working group, by legal, and also by any member or any of those present in the hearing. We allow that, sir. Sometimes, well, actually, when we hear the cases, more often than not, we allow suspension of the proceedings, of the formal proceedings, so that the public can better ask questions and whatnot, but still it's recorded. And then whatever might be necessary to be included can then be presented later on. To bring the understanding or the level of appreciation of the consumers into the in such a level as what Sir Michael Pitlock was explaining, right now is really difficult. As a matter of fact, more often than not, it's either the presiding officer or the technical person who has to do the explaining. Unfortunately, we do not have the same structure that allows for a consumer group or even for the electric utility to be able to hire the technical consultants or those with an expertise to be able to assist them in the process. Much of that is actually left to the electric utility, whether it's an electric cooperative or the private distribution utility, or to the generation company itself, which actually might be too self-serving. That's why the commission itself endeavors to be the one in between to ask the questions or to make the proceeding not as technical as it could be procedurally, to be able to accommodate. Unfortunately also, because it is a legal procedure, but there still has to be some semblance of order and rules that will have to be followed, and that's where mostly the oppositors and intervenors have a beef with the commission in the manner by which the presentations are made. After that is now the pre-trial, and then where the issues are consolidated, etc., facts are admitted, etc., etc., and then going to it follows actually a courtroom, the regular courtroom procedure, and then evidentiary, etc., etc. Should there be no further issues or concerns or any opposition or intervention, then the hearing is closed or is terminated. It now goes to the commission, to the service for technical evaluation under the technical working groups that were created. The technical working group goes over all the submissions and does the evaluation. There are instances when additional documentation may be required, and an order is issued by the commission or by the oversight commissioner for that, for submission. And once the evaluation is complete, the technical working group, together with legal now service, brings that up to the commission for deliberation. That deliberation will be a discussion by the commission on the evaluation that is being presented by the technical working group. So this is where different recommendations might be had on how to set the tariff, or how to decide on what is being applied for. The structure that Mr. Pitlak actually showed in terms of the open meeting, okay, that's the open meeting. I'm not so sure, sir, but the open meeting, I am presupposing, is already this deliberation, or is it the public hearing?
Sir, if I may respond, all meetings are open, both the hearing, the
Okay.
consumer sessions, and the deliberation. So it's all of the above.
Okay. So, for the commission, as it stands now, for the ERC, the hearings where the parties are able to present their case or their application is the one that is public in nature by default. But the commission meetings, the deliberation, includes only the commission, not just the commissioners, but the technical service that was involved in the evaluation. And it follows a deliberative process and whatnot in order to arrive at the decision or the resolution of the application. That's in a nutshell, sir, how it goes.
Thank you, Commissioner. Actually, aside from listening to Michael on his experience with the Nevada regulator, we also talked to the consumer groups, no? And I think Mr. Hunya is here also to represent the consumer groups. And this proposal actually came from trying to educate, no? Kasi ngayon yung consumer groups kawawa eh, no? They pay for their own lawyers, they pay for their own economists. So ito si Mr. Hunya eh pro bono ho to, no? Na lumalaban para sa consumers, but we don't have like what Michael said, no, a government office that naturally represents the consumers. And this is where the gap comes in, because the consumers, of course, if you will protect your own interest, no, you will spend for it. But the consumers are fragmented. That's what we want to address also. But more importantly, how to educate them, because even me, no, the ordinary consumer, it's very difficult to understand how rates are being determined. And one of the principles here is the more open, the more informed the consumers will be, the better for them to understand. But that's only one part. No, the other part really is we're thinking of asking government somehow to represent the consumers in rate setting activities. Mr. Unya?
Thank you, Mr. Chairman. I just wanted to react to some of the points that I've been hearing since I caught up with the session. First, on the presentation made by Commissioner Asirit on the process, Mr. Chairman, we have particular interest on the rules on the filing of the application, because this has come into play precisely in the 7 Meralco power supply agreements. Commissioner Asirit says that there's a pre-filing conference after which the filing and the docketing is actually done. We're concerned with that because the rules say that compliance with the pre-filing requirements should be done before a case is docketed or numbered. And this is critical in the 7 PSAs. It has come out that out of the 7, only 3 had timestamps on them, and these were all after 5 o'clock in the afternoon. The 4 did not have any timestamp. In other words, before the 7 applications should have been accepted, all the pre-filing requirements should have been complied with, and they are all enumerated in the rules. So we're concerned that there might have been some shortfalls in the prior compliance with the pre-filing requirements. And when the commission comes in and in a very cavalier manner tells us that the filing can be complied with afterwards. And this was also essentially the letter of Commissioner Non to the House committee that is conducting an investigation on the 7 PSAs, that compliance with the pre-filing requirements can be done after filing. I'm afraid, Mr. Chairman, that's putting the cart before the horse, or something is not right there. So I think whether this committee or the other committee in the other chamber should be looking closely at the rules and regulations and the level of compliance of the commission with these rules in relation to pending issues or pending applications in the commission. Second, the way that the applications are deliberated on or conducted in the commission right now, the first hearing actually rolls into one the 3 aspects: the jurisdictional, the expository, and the evidentiary hearing. You can imagine, Mr. Chairman, if it is a 1,000 megawatt power supply agreement, the information and the data is going to be huge as far as that application is concerned. And when you roll up all three hearings, jurisdictional, evidentiary, and expository, into one session on the first day, consumers are really hard put at catching up on what kind of position or how we can position ourselves in relation to the application. When the hearing is conducted, and I understand in the previous committee hearing, this was pointed out by one of the resource persons. Normally, it's just a hearing officer. Delete the word just. It's a hearing officer that conducts the actual hearing. There was only one case I recall in some of the cases that I have been involved in, where the hearing officer precisely asked for the presence of somebody technical from the Energy Regulatory Commission. I think at that time, somebody from ROS was required to attend and listen to the deliberations. Normally, it's just the hearing officer, the lawyer, and the applicant and the oppositors who are there in the deliberations. What is alarming is that from what I saw in some of the commission transcripts that were submitted to the House, it would look like that when the commission deliberates, they just listen to the presentation of the technical group. I suppose it's the ROS or one of the technical units of the commission. And what gets downloaded or uploaded to the commission is the findings or the recommendations of this technical group, and I'm afraid not necessarily the full record of the deliberations. So I'm glad that Mr. Pitlack has shared with us the experience in Nevada, because that is exactly the kind of regulation that we would look for in our here in ERC. That the open meetings, the technical inputs, etc., etc. The other point, and by the way, Mr. Chairman, one of the transcripts that I saw, sabi nga ho ng isang commissioner after having decided on a pending application. I try to recall what was said in the transcript. Sabi nga niya, di kaya tayo kulamin ng applicant dito sa decision natin. I mean, I suppose that captures the essence of the commission deliberations. Anyway, to another point, Mr. Chairman, earlier there was also mention of budget, and it was in relation to the working relationship between the chairman and the executive director. But just to comment on the budget, excuse me. Just to comment on the budget, Mr. Chairman, we had always been concerned about what is the real cost of regulation. While the Commission submits a budget to the House, now it's, I think, anywhere between 150 or thereabouts, 150 million. Our concern is what exactly is the real cost of regulation. Reference was made, or mention was made earlier, about consultants and experts. Mr. Chairman, we, the Meralco customers, are being charged 2.2 billion pesos for the third regulatory period to cover what is called a regulatory liaison and compliance fund, which by description in the rules for setting distribution wheeling rates that was promulgated by the Commission is used to pay for consultants. We are also charged another item amounting to 201 million pesos, also for the third regulatory period, as Meralco customers for so-called regulatory reset experts. So, if there are experts, if there are consultants, and their job is to help facilitate the regulatory process of the Commission, then they must be considered as cost of regulation. And all these charges, regulatory liaison and compliance and regulatory reset experts, are charged to us directly. Again, a concern for us is, one, I have been nagging actually the Commission to give us a list of the consultants, their consultancy contracts, the reports and the outputs of their consultancies, because after all, their cost had been charged to us. But I had been getting the runaround, and I haven't gotten any forthright and direct answer on my queries. And I do hope that when your bill is finally enacted into law, then this kind of avoidance of giving of documents can be minimized, and we will be able to get the data that we require. But the point I'm making, Mr. Chairman, is that there are costs that we have to bear as part of regulation, and we are still looking for a substantial compliance with our requests for the outputs of those consultants and consultancies.
Upo na ba ho kayo sa mga hearings? Have you attended the...
Mr. Chairman, I have been a party to several. I was a party to the ERC case 2010-069, which is the application for the third regulatory period.
So you've sat in those hearings?
I have sat through hearings,
So-
and Mr. Chairman, in one particular case, ERC case 2012-054, which is the application for rate translation for regulatory year 2013, I had to, I made a manifestation to withdraw my intervention for the simple reason that I felt that I wasn't getting a fair and just rulings from the Energy Regulatory Commission. And since, as I pointed out to the Commission, I did not have the money to pay for a lawyer to appeal their decisions to the Court of Appeals, I withdrew my intervention or my intervention in that particular application. The only reason why I intervened was because I was hoping that I would be able to raise the matter up to the Court of Appeals and hold the Commission accountable for their decisions. Mr. Chairman, within the Commission, up to that time or up to this time, I have yet to see decisions that I would consider as fair and reasonable to the consumers. In this particular case, if I may share with the committee, Mr. Chairman, I was asking for my motion was on the basis of what I saw as a violation of the applicant Meralco of the rules of the Energy Regulatory Commission as far as production of documents was concerned. And despite the fact that I submitted the Commission's own rules, which were literally transgressed by the applicant, and despite the fact that I submitted the whole copy of the transcript, which was actually quoted selectively by Meralco in their opposition to my motion, the decision of the Commission was still adverse to me, and I said, this is hopeless. Since I cannot appeal this, I will withdraw my
So,
intervention.
Mr. Hunya, top of mind, what do you want to improve? Ano
Well-
gusto niyong, if you've sat in those hearings, you've been through a lot of these battles, what do you want to improve?
Well, one, I'd like to see a commission that would have
In the process, in the process.
in the process. Well, the presentation or the presentation of Mr. Pitlock would be an ideal setup for the commission. That one, we should have a consumer advocate. I have read some decisions, particularly on PBR, of other regulatory regimes, specifically Alberta, Canada. And it is very clear there that they have a utility consumer advocate who is actively involved in the manner described by Mr. Pitlock. And even in the decision itself, it is laid out very clearly that the position of the regulator, the position of the utility consumer advocate, and the position of the utility applicant. And as the basis for whatever is the outcome or the decision of the regulator. So the improvement that we would like to see, or the change that we would like to see in the commission is one, a commission that would really be hands-on and attending and doing the hearings themselves. Second, the technical group being a real resource in terms of vetting or verifying or checking the applications. Mr. Chairman, in relation to 2010-069, the PBR, which is the current process for the approval of the rates of the distribution utilities, there is a draft determination and there is a final determination which becomes the basis of the final rate. I was really taken aback and surprised when I saw in the draft determination for that particular case that the prefatory statement of the Regulatory Operation Service of ERC, ang nakalagay po doon, ROS did not look into the details of the applicant's numbers, etc., etc. So if there's something wrong with it, don't blame us. I mean, words to that effect. To read something like that from a regulator, that was shocking. And from that point to now, until probably SB 1490 is in place, I do not see any hope for any much change in the way things are going on at the Commission. Very recent lang, Mr. Chairman, the way that the 7 PSAs are being handled, Redondo Peninsula, one of the cases, rushing through the final approval process and lumping together and juxtaposing orders that would facilitate the final approval and the final determination nandyan ho sa records ng ng case na yon.
Mr. Hunya, thank you. Thank you. Commissioner Asarit, doon sa, when it reached the deliberation level, this is purely commission already.
Yes, sir.
Wala ng consumers.
Wala na, sir.
Wala na
Wala
ring
na, sir.
applicant.
Wala rin, sir.
So this is purely commission.
Yes, sir.
So at the hearing level, this is where they present their evidences.
Yes, sir. And just to clarify, in each hearing, perhaps what Mr. Hunya was saying earlier about the participation of a technical person might have been an exception. That's why the person had to be called. Because the team actually is composed of the hearing officer, the one who clerks for the commission, and then a legal and a technical person from the Regulatory Operations Service. That's a must because it's actually the Regulatory Operations Service personnel or staff that conducts most of the questioning, especially on the technical aspect. It's also worthwhile to note, sir, that yes, we agree with Mr. Hunya that there should be more participation, perhaps, of the commissioners, maybe even at the hearing level, and that's actually one thing which we were able to address because the commission actually has what we call oversight functions of areas. And therefore, like for example, I have oversight on Region 8, and then some SPUG areas, small power utility group areas, Mindanao, across, for example, Luzon, Visayas, Mindanao, I have oversight functions on those. I actually hold hearings for those areas. I do go, and that's why I know how the process goes. For Meralco and GCP, cases, however, the oversight commissioner for that is actually the chair. And during the time of then the former chairman, actually he was the only, he had a pronouncement that there were only certain personnel or staff and even officials of the commission, of the agency, who could conduct the hearings, which meant him, because he had oversight over that. So we do conduct hearings, sir. If you will ask, I mean, I think Ms. Attorney Balite would be able to attest to the fact that the commissioners do go out. We hold public consultations. We do present ourselves in those public consultations. Sometimes we have, we assign, so for Luzon, Visayas, and Mindanao, there is at least one or two of the commissioners who would be able to attend those consultations in tandem.
Mr. Chairman,
Yes,
Mr. Chair, may I?
just for the record, I stopped by my earlier statement that there were no technical staff in the hearings that I had attended, except for, as I recall, about one, just one. And I'm sure the records will bear me out that there was no ROS representative in those hearings. And second, the only time that I saw a member of the commission attending a Meralco hearing was, I think, during the time of Chairman Ducot, and it was just a jurisdictional hearing, after which, when jurisdiction was already declared or acquired, it was already adjourned. But when the actual deliberations on the merits were already being done, it was a hearing officer. Not that I have anything against the hearing officers, but I'm just afraid that when the commissioners themselves are not the ones conducting the hearing, the risk of something being lost in translation is certainly very high.
I understand that, Mr. Hunya. That's why in the TWGs, normally I sit also. Because not naman that I'm saying the staff cannot do it, but sometimes when you are passionate about the bill, you want to make sure that your passion gets included in that bill, no? Because it gets lost in the debate and in the discussion. I understand where you're coming from. Paul, Attorney Paul?
Thank you, Mr. Chair. Since our representation was mentioned by the good commissioner earlier, we can attest that the commission sends very fine individuals to even far-flung areas where transportation is very difficult to be accessed in order to conduct hearings so that the consumers may be heard and other stakeholders as well. Be that as it may, our representation would like to invite this committee, as we are discussing the ERC governance bill, to address that particular difficulty. And I think that by considering even going to an ERC charter where divisions of the ERC will be empowered so that those who are in Metro Manila will not have to go to far-flung areas in Mindanao, so that the people, the consumers in those areas will not have to go to Metro Manila in order to file necessary pleadings or to be represented. Also, we share the sentiment of FDC that perhaps we should also re-examine the possibility of creating the office of the consumer advocate. Actually, I am new to the program of rural electrification, but many from the rural electrification program have already voiced this sentiment for a long time, that there should be a dedicated office to represent the consumer interest. So, Mr. Chair, we are very excited as we deliberate further on this ERC governance bill. Even in the House, there are corresponding versions in order to strengthen the regulator. Thank you, Mr. Chair.
Mr. Chair.
Larry?
We'd just like to add to the description of the process earlier gave by Commissioner Acerit on the characteristic of the expository hearing. While it's called the expository hearing, no one is required to actually make a formal representation. It's really open to the public. So I think that's an innovation of the Commission that will allow any audience, any party in the audience, without having to make a formal intervention first or anything, to participate in the process and ask questions. And then in the middle, specifically for the PBR process, I think that's another part of the rule rate setting process that was not described earlier. That even before they make that pre-filing process, the ERC develops rules for rate setting, whether it's rate setting for pass-through charges or rate setting for distribution charges. Even before a hearing itself, there is a rule-making process that is also open to the public. There is public consultation, there is submission of reports that do not require formally having to intervene. And those rules will govern the hearing process and the evaluation of the rate application. Now, specific to the PBR process, not the entire hearing process is confined to parties. As mentioned by Mr. Hunya, there is a draft determination. That draft determination, and I'm not sure where Mr. Hunya says that prefatory statement about the RS not having seen the numbers, but I'm reading from the draft determination of Meralco for the third regulatory period. In the penultimate paragraph, it says that pursuant to the RDWR, consideration of the information after consideration of the information provided by the regulated entities such as Meralco and the reports prepared by its regulatory experts or the regulatory experts of the ERC is required to publish a draft determination on the price control arrangements. So this is from the draft determination for Meralco. This document or the draft determination presents the ERC's draft determination for Meralco. So it's the commission. The commission owns the draft determination, and the ERC publishes that draft determination on its website and invites the public to submit comments. If you will look at the draft determination, it's a thick document that has a lot of information, and the public is invited to comment on it. You don't even have to be a formal party to the case to submit comments to the draft determination. That will become part of the consideration in the final determination that will be promulgated by the commission. So that's specific to the PBR for NGCP and private distribution utilities.
Thank you, Larry.
Mr.
Someone
Chair-
is raising. Let's Attorney Hannah first. No?
Good morning, everyone. Good morning, Chair. Good morning to the fellow stakeholders. We submitted our official position paper, which highlighted the transparency and accountability as a means of strengthening governance in the ERC's regulatory function in the power industry. In our position paper, we highlighted that consumer groups should be recognized as necessary parties in cases which ultimately affect the end users, the consumers. In our interventions in the ERC, Citizen Watch has been treated both as an intervener and has an oppositor status, which entail different rights. This creates a disjunction of legal status which needs to be corrected, as consumer groups who are treated as oppositors do not necessarily oppose the proceedings, but the consumer groups merely ensure that the least cost and the most beneficial rates are given to the end users. In our pending cases in the ERC, we are treated as interveners to some of the cases and as oppositors to some of the cases. I think this needs to be corrected. I think to be uniformed, the consumer groups should have a guaranteed spot as necessary parties to the cases. This may be subject to the approval of the Consumer Support Office for the identification issues and for the possible consolidation of the consumer concerns. We also welcome the suggestion of Mr. Michael Pitlock in terms of the Consumer Advocate Support Office and consumer sessions to address the needs of the consumers. We need to institutionalize the Consumer Advocate Support Office. We also encourage the creation of the Consumer Advocate Technical Working Group under the Consumer Advocate Support Office to assist the different consumer groups in the technical process. In our experience with the ERC, sometimes there would be delays because we would ask to, in order to make an informed decision or judgment, we would ask the ERC to explain the technical inputs because we cannot fully grasp the technical process of it. And I think in a previous, I think it was a hearing regarding the rate setting methodology. Engineer Ortega, I think in that hearing, explained the rate setting methodology, which was beneficial for us, but also caused delays because as consumer groups, we are not fully informed or fully competent enough to understand the technical process of the entire rate setting methodology.
Attorney Hannah. Mr. Onya, you're raising your hands.
Yes, Mr. Chairman. About the PBR, there are really many questions there, Mr. Chairman, that we would want to raise, but some of it we already raised in the previous hearing, and maybe it can be tackled under another.
Well, we're more than happy to listen to your arguments in later on. I need to dig deeper into your arguments also, so we can raise that in a different session. But I want to understand where you're coming from. I want to understand your logic so that next time we engage the Commission and the other stakeholders will be guided accordingly.
Well, I just wanted to say, Mr. Chairman, that as far as PBR is concerned, which is the rate setting methodology that was adopted or they shifted to sometime in around 2003 or 2004, there has been no rate reset since July 1 of 2015, and all the rates that are being charged now under PBR are under an interim arrangement, the interim average rate. Second, Mr. Chairman, while the process was actually belatedly triggered in 2014 or 2015, when the Commission adopted the rate reset order in July of 2016, the utilities given until November of 2017 to file their application for rate reset, I do not know if any utility has already filed. I do not think Meralco has filed for rate reset. Mr. Chairman, it's very important to us that the rate reset process be undertaken because under the PBR rules of the Energy Regulatory Commission, the rates that are charged to us as distribution, supply, and metering charge of Meralco can only be questioned, or the utilities can only be questioned or challenged in a rate reset process. Barring the rate reset, there is no way that the consumers can question the charges of Meralco. In fact, in the so-called rate translation that happens every year after the rate reset, when consumers question the charges of the utilities, the usual answer is
Just focus on what is the topic at hand, which is the Governance Act. And right now the topic is open meetings, no? And that's why I want to also ask the chair or Commissioner Asirit, in the proposed measure, we will open the deliberations, no? And what are your concerns in opening up the deliberations to the public, no? Sa ngayon ba ho merong executive session? Is there such a thing as executive session right now?
Well, if what we mean by executive session is just a session attended by ERC officials and technical and the other staff, then we have one. The inputs from the public are taken care of in other public meetings and hearings, including the expository hearing, which is done in the service area, where rules are relaxed. There is really there may be a need for us to review on the rules that ERC has promulgated regarding the participation of the consumers, whether as an intervenor or as an oppositor, because we have timelines. We have imposed timelines, and if a consumer group did not beat the timeline for filing an intervention, then they are treated as oppositors. There's really a problem when it comes to the consumer meaningful participation. We recognize the fact that for example, they don't really have that kind of legal support that they need. In fact, that's the reason why, and Mr. Hunya knows about it, that we have recognized that we have already talked with the PAO. But again, the reservation that we have is that it's ERC's initiative. Although the purpose is to help empower the consumers, again, it is ERC's initiative, which might not be taken positively by other consumer groups. But this initiative is in process already, and we expect some trainings to be given to the lawyers who will be assisting the consumer groups. Maybe Butch Hunya can be one of the lecturers there. Thank you.
Madam Chair, did you see, and what's your earlier in the session you mentioned or you had some hesitation on opening the deliberations to the public. What are your hesitations?
Well, the hesitation is being taken out of context because during the deliberations, as I said, one commissioners can say, okay, I'll take the devil's advocate. I'll take the consumer's side, because that really happens in our deliberations. So those are the sources of my hesitation. Not for anything, Your Honor. In fact, upon presentation by Mr. Michael of the model in Nevada, parang gusto ko nang mag-apply doon. Napaka-strong ng structure. That's why it's very mature. For us, parang we make do. We come up with something for the consumer to help but you know, we are the ones helping. And for clarification, whatever the DUs may have appropriated, and thank you for calling my attention. And I asked that's why I went out. I asked the head of of our finance, whatever may be the budget in some of the GenCos or DUs, this fund does not come or is not given to ERC. But let me look into this more deeply. And whatever ERC spends for technical consultants, these are not passed on to the consumer. These are government expenditures to shoulder the cost of regulation. Thank you.
Madam Chair, let me just understand again, no, or for information of everyone. After the deliberation, you released the resolution. No?
Yes, Your Honor.
Do you also released the minutes, or is there any?
There's a lag, definitely,
Okay,
because minutes will have to be, as we know,
right.
They will have to write it down.
But is there a definitely the resolution is posted? It's released to the public.
Yes, yes,
In
Your Honor.
discussion, is there anything that
The deliberations, Your Honor.
Yes, the deliberation.
The
Any document
deliberation,
where the public can
well,
see the
Ah.
deliberations?
reference should be to the minutes.
Okay.
Unfortunately, because of the load of work, we are unable to even finish
The minutes.
the minutes of every meeting in time, even for the next commission
But the
meeting, which is
minutes-
weekly,
The minutes is available upon request.
upon request.
So, for example, if someone will request for the minutes of a particular deliberation,
Mhm.
that can be provided.
That can be provided.
Okay.
Provided, again, our stenographers are done with the writing
Okay. All right.
and the summation.
All right. And again, going back, no, Madam Chair, I understand, no, there's the dynamics inside of your deliberation, and assuming we open that to the public, the dynamics will it be favorable or unfavorable to the consumers?
For as long as nobody is quoted out of context, then it's favorable.
Okay. I'm just trying to understand the dynamics of this, again, I'm just, if I compare that to our deliberations here in the Senate, no, because the Senate deliberations are open, and of course, some people would opt to debate and to deliberate. Some people will just opt to vote, no, without saying anything. At the end of the day, pinaka-importante naman yung vote, no? So, but we are also given a chance to have our own executive session. The difference is we don't publish the summary of the executive session unless the members will agree, no? Majority of the members will agree to publish the deliberation. But otherwise, it's a confidential deliberation, no?
Your Honor, on that point of confidential information, because this is business, these are things that we think should not be made available to the public because negosyo po nila yun eh. There is always, in fact, at the very start of the proceedings, there is always a request for treatment of confidentiality of some of the information included in the application.
Mr. Chairman,
Yes.
just a quick response to the last item on confidentiality. I think that collision of interests here will occur because as the ratepayers, we feel that we should be entitled to know what we are paying for. Besides, the principle for rates charged to us is that for the operating cost, for instance, it should be reasonable, prudent, necessary, recurring, and redounding to our benefit. So given the criteria for determining the recoverability, we will need to have access to certain information that will guide us in appreciating whether it passes muster on chargeability. While we recognize that corporate, patented, or private information can be entitled to confidentiality, there should also be a consideration for the interest of the consumers to know whether it is a chargeable or recoverable cost. Perhaps in the finalization of the bill, a clearer policy can be laid out in arriving at a determination of what is confidential and what is not confidential. In most cases, in the applications of the utilities, it is a matter of routine that certain information is requested or considered confidential. So I think there should really be a clear path or a clear process towards arriving at a determination based on a balancing of the interest of the ratepayer and the interest of the utility. And to another point that was raised earlier on the contracts and the budget, I just want it of record, Mr. Chairman, that where we're coming from as far as those consultancies and fees are concerned, it is actually written in the rules of ERC, the RDWR, that when the commission is obligated, I think the term used there was obligated, to hire a technical consultant, it is going to be charged against the Regulatory Liaison and Compliance Fund. The Regulatory Liaison and Compliance Fund is defined in the RDWR. And also, Mr. Chairman, in the RDWR, there is a footnote that says the utilities, 18 PBR utilities in all, or 17, have entered into a memorandum of agreement with the PEPUA, the Electric Plant Operators Association, as the one that represents them in contracting the services of consultants. That's actually the information that we've been trying to get from the Energy Regulatory Commission, and we haven't gotten any direct answers.
Sige po, Mr. Hanya, thank you very much, and I'm sure the Commission is taking note of your concerns and your request, and also the issue on the rate-setting dates.
And by the way, Mr. Chairman, let me just add that the new commissioner has actually sat down with us, and she has been very kind to listen to us. But as you know, Mr. Chairman, answers also matter as much as the questions. So while we have been given the opportunity to raise the questions, we're still waiting for some of the answers. Thank
I'm
you.
sure they're in the process of satisfying your request and your answers. Later on, we'll have that session. In the topic of open meetings, particularly opening the deliberations to the public, any feedback from, any comments from the stakeholders? Any comments on the confidentiality in particular? Kasi kayo yung mga nag-a-apply, no? Sila, Attorney Ani, I'm sure siya yung mga nag-a-apply. Sila, Attorney Ocampo, yung mga nag-a-apply sa utility. Any comment, Attorney Ocampo, on the confidentiality, especially when you apply for rates or apply to the ERC for that matter?
Your Honor, thank you. We defer to the comment of the ERC Chair, Your Honor, and we support that her position on the confidentiality of the Commission deliberation. But insofar as the minutes of the deliberations are concerned, maybe Mr. Hunya has a point that it should also be made available to the stakeholders. At least we would know what would be the rationale for a particular resolution.
Ernie, are you raising your hands?
Thank you, Mr. Chair. I think MAP already submitted its position paper. Just basically on the two items, which is the chairman and ED having CEO and COO. But on the issue specifically on the open meetings, we strongly support the position, Mr. Chair, of having open meetings in order to make sure that all of the discussions and all of the points both by the oppositors or the applicants and so forth, so on, are duly noted and discussed thoroughly. We feel that, as Michael had indicated earlier, an open discussion on the merits of whatever are the issues that are being discussed, whether it's rate, the basis, the rate, return on investment, and these items are discussed in public settings so as to provide also the consumers and the business sector that we represent, so we can explain to them, just in case we are asked, what happened, what's the rate, what's the basis of these rates, and so forth, so on. We can somehow discuss it with them intelligently if these are in open session. So we support the open session. Mr. Chair.
Open session in the deliberations.
Yes, Mr. Chair.
Okay. Have you, itong mga open sessions, there are, I acknowledge the confidentiality of some of the items, so specifically the commercial component of the discussion. How do you address that, Ernie?
Well, Mr. Chair, well, I used to be one of the generators or represent, or even the case of NREB as on the feed-in tariff as an NREB board in order to justify the basis for the feed-in tariffs. I mean, these are all public information. Now, with respect to particular like project cost estimates, debt equity ratios, and so forth, so on, I think, Mr. Chair, there's enough for particular projects, even power projects, so, that there are applications with the Board of Investments, as an example, wherein which the Board of Investments hold also all of this information and then discusses this publicly, and you can easily get those from the BOI. So I don't see why certain data should be treated confidential, particularly because there has to be proper deliberations on costings, as an example. What are these reasonable, as Mr. Hunyan was saying, are these reasonable costings that are being done with respect to operating costs? So, there must be some basis for discussions on this. No? If it's treated as confidential, then how do you know whether... I'm not casting doubt on the process. It's just for the sake of transparency that one cost versus one coal plant operating cost versus another plant's operating costs are taken into consideration, such that as a consumer or as business sector, it's important that we know that these were properly or can be properly defended. And we think that this can only be done in a public setting or open discussions.
Ernie, you mentioned earlier when a particular business, for example, in this case, a power plant applies to the BOI, it indicates the cost of the plant. That's open to the public?
Yes, Mr. Chair.
So you can, ano yan, in deliberation nila, open rin, or you request? May board rin yan no?
There is a board, Mr. Chair, before you're granted the incentives, and you can request for the information, and then the information...
And they will give it to anyone who requests the
I think
information.
if you have a reasonable grounds for doing so.
Okay,
Mr. Chair.
thank you. Any comments, Rio? Comments? Michael, any?
Mr. Chair, with respect to confidentiality, first of all, the ERC already has a procedure for dealing with requests for confidentiality. A point I think you need to make is you need to separate what is being held confidential from the regulator as opposed to what is being held confidential from the general public. Nothing is confidential to the regulator, or nothing should be confidential to the regulator. They should have access to everything. In our hearing proceedings in Nevada, all of the interveners, whether it was the staff or the consumer advocate or an industrial customer, was given access to all the information. Some of it would be subject to a non-disclosure agreement, and the consumer advocate would have to sign that non-disclosure agreement. So they have access for purposes of evaluating their case and evaluating the application, but they're precluded from disseminating it to the general public. So you need to make sure that the commission, the process, has access to the information in a way that still protects the confidentiality from the general public through non-disclosure agreements.
All right, thank you, Michael. And any final words regarding the open meetings and particularly opening the deliberations to the public. This is actually in the more on the transparency issues. No? Any last comments po regarding this? Attorney Arquisa, any comments regarding transparency and open meetings?
There should always be transparency, and we will measure it on the basis of the best interest of the public.
Thank you. Madam Chair, you have the final word.
Thank you, Mr. Chairman. With all the inputs, particularly the last input of Mr. Michael, we have, at ERC, we have to really study the extent and the nature of what should be kept confidential, in the sense that it can be disclosed to participants in the cases, but without releasing that to the public. And because of some sensitivity, which I am not ready to take a position on. And we would like to submit this particular issue to the committee, and we trust that it is for transparency. Thank you.
Thank you, Madam Chair. I think we tackled the two main issues here, no? Which is the delineation between the CEO and the COO, their roles and their scope in terms of responsibility. And the other one is the open meetings. No? I think we extensively deliberated on that. Ako naman po ang merong Valentine's gift sa inyo. No? Hindi ho date yan, ma'am, kasi alam ko may date kayo mamaya. I think after hearing Michael earlier and the chair, we'll be including a provision on income retention. Commissioner Aserit and the other commissioners have been working very hard on this. In fact, ma'am, parating may singit yan sa GAA, no? We're always including a special provision in that, in the GAA, but for some reason, it's always struck down by the Office of the President. And I think one of the reasons is the absence of a legal basis for the retention. So I think to improve the governance of ERC, you need to equip it with funds and with capacity. No? And that also goes to the next suggestion of Attorney Pete, which is opening up other offices in Visayas and Mindanao. But we can only do that if we have funds. No? So we work on the funds first, and then later on, we can encourage or even include in the bill an opening of an office in Visayas and Mindanao. No? That's up for discussion, but definitely will include a provision on income retention. I think we have extensively discussed the ERC Governance Reform Act and the important points. If you have any more last position paper, you can submit it to us on or before February 19. You will still deliberate and discuss whether we have covered enough detail to go into a technical working group. But we will advise you if ever we have decided that a technical working group is necessary. No. Before we terminate this hearing, merong lang konting housekeeping. Nasa agenda ba ito? You have to read it, ba? Okay. We have a little housekeeping procedure. A few months ago, Senator Zubiri filed a resolution, Senate Resolution 133, entitled "A Resolution Directing the Senate Committee on Energy to Conduct an Investigation in Aid of Legislation on the Impending Power Disconnection of the Bukidnon Subtransmission Corporation, BSTC, to the service area of the Bukidnon Second Electric Cooperative, BUSECO, in the province of Bukidnon, with the end in view of preventing the recurrence of similar events that disrupt economic activities and protect the interest of the general public." We had a hearing, kailan hearing nito? Tagal na ito. Actually, we had a hearing 2016, if I'm not mistaken. And I remember ED Neil Silva was there to represent ERC. But I'm directing the committee secretary to insert into the records the chairman's report, in which it will include the background, the issues, and the recommendation of the chairman to the resolution. So please take note, COMSEC. With that, once again, thank you very much for your participation. And just to remind you, your position paper, the last day will be February 19. And Attorney Arquisa, the computation, no? Take into consideration the updates from
months
COA,
and-
from
2 months, 6
ERC. All right, thank you. The meeting is adjourned.